All right, are you ready? Let's roll, nerds. Okay, Brock, you got an arraignment?
Yes, Your Honor.
Let's rock and roll.
Good morning, how are you?
Hey, what's new, man?
Mr. Louis Etchelberger?
Come on up.
7 and 8.
All right, so you are Mr. Etchelberger.
Yes, sir.
Sir, you're charged with two cases. You're charged with interference with the duties of a public servant. You're also charged with criminal mischief. Those cases, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Okay?
Thank you, Judge. Judge, law enforcement officers were dispatched to a disturbance call in Harris County, Texas, and made contact with a complaining witness who stated that on April 28, 2025, she observed a prior resident, the defendant, cause damage to the apartment complex after a breakup with a significant other. The complaining witness stated that the defendant broke 3 flower pots and damaged 3 trash cans for a total of $405 worth of damage. On April 29th, the defendant came to the leasing office and demanded property, I believe that was left. The complaining witness asked the defendant if he was the one that caused the damage. The defendant stated he was not. Complaining witness and a witness then tried to get the defendant to leave due to him causing a disturbance. Defendant pushed his way through complaining witness and a witness. A law enforcement officer on scene serving civil papers attempted to detain the defendant. The defendant was able to get away and run from that law enforcement officer. The defendant was later detained when other law enforcement officers arrived on scene.
So the mischief, it's at an apartment,
That's correct, Your Honor.
his apartment?
I believe he was a prior resident of the apartments, Your Honor, and the property belonged to the apartment complex.
And that was my question this morning, Your Honor. I haven't stayed in an apartment in a long time, so typically apartment complexes don't give their property at a residence specific apartment complex.
You mean furnished?
Wait, flower pots and trash cans? The defendant allegedly broke property belonging to the apartment complex after a breakup, causing a whopping $45 worth of damage. This highlights a key legal distinction: petty mischief versus a family dispute. The value is almost irrelevant, but the intent and the complainant are everything. If the items belong to the ex-partner, it's a civil issue. Because the apartment complex is complaining, it's criminal mischief. But $45? Is this really the best use of court time? What do you think?
Furniture, it's flower pots. I mean, why would an apartment complex have their flower pots out in front of a resident's apartment?
Okay, what all was allegedly broken again?
3 flower pots and 3 trash cans, Your Honor.
Are you saying it belongs to him? What are you saying?
I believe it belongs to him or to the partner, the former partner, the leasees, the people that lease the actual
Because if
premises.
it belongs to the other person, then it's a criminal mischief. You can't break someone else's property.
But he's not the complainant. The complainant is the leasing manager for the apartment complex. They're alleging that the property belongs to the apartment complex.
Your Honor, from the DEMS, it says that each 3 trash cans were $35 each. They're placed outside for residents to use for trash bags on all 3 levels of Building 8, causing the property to.
So it's like, it must be, cans that officers put out there in case anyone needs to put trash in or whatnot. You know what I mean?
Yes, sir.
As far as the interference is concerned, that I may have a problem with.
I don't see how that was interference.
Because what would they possibly put him in custody for?
So, Your Honor, just to clarify, I'm not, what the DIMS say, and they go to the great lengths to explain this, is that there was a deputy there who was serving some sort of civil papers.
Sure.
And that he had to stop serving the civil papers to go
To chase him.
detain the defendant. Because the defendant, there was a disturbance in the leasing office. And at some point during that disturbance, the defendant got away from the deputy who was serving the civil papers.
Correct.
It's not really clear from the information. Is the serving the civil papers and having to stop that duty to go detain the defendant, or is it the defendant getting away from the deputy, if that's what the basis for the interference is?
And that's correct, Your Honor. Richard and I spoke about that this morning.
The judge just dumped the interference with a public servant charge. What? Because the officer was serving civil papers, not actively enforcing a criminal law when the defendant ran. The defense successfully argued there was no clear duty to interfere with. This is a vital win for the defense, knocking out a charge because the prosecutor couldn't articulate the legal basis for the interference. The criminal mischief sticks, but the more serious charge is gone.
So you don't think there's PC on the interference?
I don't think there's PC on the interference, honestly, either way. If he's trying to serve papers,
I think I agree with you on the interference,
yes, Your Honor.
but I think that there's PC to go forward on the criminal mischief.
Yes, Your Honor.
No?
I'll dump the interference.
So I'm going to find no probable cause to go forward on the interference. I don't think that they had a reason to, have you in custody or for you to interfere with.
Yes, sir.
I will find that there's probable cause to go forward on the criminal mischief. Is he staying there now or is he gone?
No, Your Honor. I think both individuals have moved away from the apartment
Okay,
complex.
so Mr. Eichelberger, the only thing I'm going to ask you now, well, I'm going to order you is not to go back to this place, not to have contact with the complaining witness.
I
Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond, not to be in possession of weapons as well. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Brock and he'll tell you if and when you have to come back to court. Just stay out of trouble. Don't pick up any new cases. I don't want to have to put you in jail.
I
You
understand.
become a danger to my community. It's not going to go well for you. You understand?
Yes, sir.
Okay. So for now, I'll have you go to Victoria, sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it. And then after that, you're free to go.
All right, thank you.
Thank you, Your Honor. May I be excused?
Yes, sir.
Thank you.
Martha, do you have an arrangement?
No, there's still an arraignment. Okay.
Yeah, I don't think that there's much, but
Okay, no problem.
All right, Judge, page 10, Gonzalez, come on up.
all right. Good morning, Ms. Gonzalez.
Good morning.
Ma'am, you're charged with terroristic threat of a family or a household member. That kicks it up to a class A misdemeanor, so you were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Judge, on March 20th, 2024 in Harris County, Texas, officers responded to a terroristic threat call. The complaining witness and the defendant are sisters, and complaining witness say the defendant is not allowed to go into a residence. The complaining witness's son mistakenly let the defendant and her husband in, and they drank a beer. The complaining witness texted the defendant about her being in the residence, and the defendant responded with threatening messages that said the defendant will slap CW and show up at, slap the complaining witness and show up at the complaining witness's job. The complaining witness stated she feared for her safety.
What the hell does that mean? It's got to be serious bodily injury, man, or
Yes, Judge.
are we putting everybody in jail now for whatever?
Judge, that's really all I have.
Statute.
Sure.
Okay, what was it said exactly again?
Judge, the message that the defendant sent to complaining witness states, exactly, bitch, don't talk out your ass because I will go to your house and slap you in front of your family. I'll even come to your job.
That's not imminent serious bodily injury. Come on. All right, I'm gonna find no probable cause, ma'am. As the old adage says, sticks and stones, right? Words will never hurt. They actually can. You have to be careful what you say, who you say it to, because it could end you, you could end up in hot water. I'm gonna find no probable cause in this case. The idea also is that if you don't have a good relationship with someone, it's probably best not to just inject yourself repeatedly in there because you're asking for trouble,
Right.
I mean, you now know. All right, man, please, just be careful, all right?
Your Honor, I'm filing dismissal.
Thanks. All right, ma'am, your case is being dismissed. If you want to copy the dismissal, you're free to wait. Otherwise, you're free to go. Okay.
All right, Judge, next is page 12. Guzman, come on up.
You are here, Guzman.
Sorry.
Mr. Guzman, you're charged with two cases. You're charged with assault of a family member. You're also charged with driving while intoxicated. On the assault case, you're facing up to a year in jail and or a $4,000 fine. And on the DWI, you're facing up to jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Thank you, Your Honor. On April 29th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle with an expired registration and initiated a traffic stop. The law enforcement officer made contact with the defendant driver and observed a strong odor of alcoholic beverage. The defendant admitted that he had an open container of an alcoholic beverage in the back seat and admitted to drinking 2 to 3 beers.
While driving?
It's not clear as to when the drinking occurred. I'll check further in the dim summary. The law enforcement officer found an open 16-ounce Miller Lite can, half empty and cold to the touch under the driver's seat. The law enforcement officer observed the defendant to have unbalanced and a strong odor of alcoholic beverage. Standard field sobriety tests were conducted. A 4 out of 6 on the HGN, a 1 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant consented to providing a breath sample and blew a .112 and a .111.
Okay, now we have an assault, right?
Yes, sir, that one is open. And we need
Whoa. Whoa, so that was an open case.
Listen, Judge? That one was a open warrant for a few months. A non-arrest?
Okay, do you mind reading me what happened on the assault, please?
Absolutely, Your Honor. On March 1st, 2025, in Harris County, Texas, officers were dispatched to a family assault. A law enforcement officer met with the complaining witness who stated that the defendant is her ex-boyfriend. The complaining witness stated that they got into an
The alleged motive for the assault? The complaining witness's inability to make him a sandwich. This detail immediately raises the emotional stakes and the volatile nature of the relationship, leading to extremely serious violence. Closing a door on her hand and then biting her while she was holding a child. This is no longer just a DWI arraignment, it's a dual domestic violence case, and the judge's focus is about to shift entirely to community safety.
argument over the complaining witness's inability to make him a sandwich. The complaining witness tried to stop the defendant from leaving, but the defendant closed the door on her hand. Later, the complaining witness was holding her child when the defendant bit her, causing bite marks and a bruise. The complaining witness stated that the defendant has assaulted her before, but she never reported it.
Mr. Guzman, I'm going to find that there's probable cause to go forward with your case on both cases. I am ordering you as a, can you look to see any prior DWIs, please?
Yes, Judge.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I would think that it's freaking elementary that you're not to have alcohol in the car while you are driving. I am now taking away your privilege to drive. You are not allowed to drive for any reason. I don't care where you have to go. I don't care what you have to do. I don't care that you have to work. I don't care if there's a burning building and you have to save 50 kittens. You get into a car and drive. You will be signing an affidavit. This is a promise you're making to me that you're not going to drive. If you do, every single time that you do, I can have a contempt hearing.
This is a serious legal warning. Every time the defendant drives, he faces a contempt hearing, risking an additional 6 months and a $500 fine per violation. The judge isn't just threatening, she's establishing a legal framework for immediate, repeated punishment without waiting for a new charge. She's making it crystal clear that violating the protective order is the capital murder of misdemeanors, the highest level of severity in her court.
You could be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand me? I'm also finding that there's probable cause to go forward on your assault case, and I'm barring you having any contact with this complaining witness. There is a protective order that has been issued in this case. Get to know it, because if you do something to violate the protective order, the state can and probably will file additional charges against you. A violation of protective order, and that is the capital murder of misdemeanors. Mr. Guzman, I'm going to protect every single person in this county, whether they're on the street, whether they're on foot, whether they're on the house. And if you become a danger to my community, I only have one place for you. And I don't know who you have in this life, but if I put your bond at 10 to 20,000, if you don't have anyone to pay it, you will be stuck like Chuck in there until these cases are over with. Do you understand?
Yes, sir.
Any prerogative, yes?
No, Your Honor.
Okay. Mr. Guzman, do you have the ability to hire a lawyer? I can have you fill out an application. I need to know everything about you. How much money you have coming in, what you're doing, what kind of car you have, any kind of retirement. I need to know everything about you, and then we'll take a look to see whether you qualify. Don't be a danger. Do you understand?
Yes, sir.
You get no more warnings. All right, Deputy Miranda.
All right, go ahead, Ms. Owen. Judge, we have one more
Okay,
on page. We're in 22 and 23. Rooker. Guzman. Rooker is sexual arraignment. Someone was attached, but from a long time ago.
I remember Mr. Rooker. So, I mean, where is he?
Rooker,
Come up, sir. Take a seat for me in the jury box. You know what? I don't, have you reached out to her? This case is 435 days old, and I know that she has a lot of history with him. I'm ready to put these babies to bed. So appointing another lawyer, it's going to take another month or two, and I don't want to do that. So who are you guys?
We're his parents.
Parents? Okay.
Can we talk?
Not yet. Let me get a lawyer. I know. We're going to try to get a hold of her.
For this month, do you want to do random drug testing
On who?
on Guzman?
But let's
You
see.
did it, yeah.
Let's see.
Are we just?
Yeah.
Judge, I actually have two cases, but they're both off docket.
Okay.
One of them is, I'll give the cause number, it's 252-5198. This one, we were here on Monday, okay? He needed to get the interlock, but he was out of town. My associate was here. You said you bond forfeited him. You said as long as he gets the interlock.
remember. Yeah,
Yes.
remember.
And then he's already filed a supervision order. And so if you could just reinstate him.
Did you get the interlock?
Yes, and he's already filed a supervision order.
Ready to go?
This is on.
I filed it, Your Honor. We signed the contract and I did file this.
Okay.
Yeah.
As long as it's good and you're filing.
It's filed it. I've already filed it. We'll probably see the part of you. And then we should.
Okay, I'll ask, I'll let her know that you reinstated it.
I did yesterday, so.
Hopefully I did. I'll talk to her in a second.
Yeah, okay.
And my other one, Judge, is a walkthrough.
Gonna bring him up?
He's my walkthrough guy. Yeah, he's out in the hallway. Let me grab him real quick.
You need a translator?
Yeah.
Okay, yeah, please.
May we approach on him?
Yes.
Okay.
And what is your cause number?
Okay.
256-1688.
You get it?
I talked to Marcus.
That's it, right?
Yes, Your Honor.
Okay, you are Kevin Vasquez.
Yes, Judge.
Mr. Vasquez, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay,
Yes, Your Honor. On April 14th, 2025, in Harris County, Texas, law enforcement officers assigned to a follow-up investigation for failure to stop and give information. The complainant advised law enforcement officers that the defendant pulled out of a parking spot and struck the complainant's vehicle in a Chick-fil-A parking lot. Complainant advised that the defendant left the scene without providing any information. Law enforcement officers went to the Chick-fil-A and found surveillance footage of the incident. Store manager stated that they recognized the defendant as one of their store employees who was on shift that day. Store manager provided the defendant's contact information. Law enforcement officers arrived at the defendant's residence and spoke to the defendant's mother, who confirmed the defendant had been driving the motor vehicle that day, but her husband was the registered owner. Defendant contacted law enforcement officers, provided his Texas ID and insurance information, and admitted driver of the motor vehicle on the date of the accident. Defendant stated he drove out of the parking lot and felt an impact, did not see anything on the ground, so he left and went home. Defendant stated he did not call the police or file a police report.
Okay. Can you run his license, please?
Yes, Your Honor. And one other thing, Your Honor, we did get a damage estimate back, just for the damage purposes.
Oh, how much? Right.
$5,000.
It's,
But we've.
yeah,
I've spoken to
we've talked about that, Judge, and we've watched the video and there's a lot of pictures of the
I mean,
damage.
it always depends on the car.
That's exactly
It's an
correct.
Lambo.
That's why. It's an Audi, but it's a 2013 Audi. So I don't know, and it may be. So we'll figure it
I
out.
think we'll be able to.
Insurance?
I'll find out. I don't know if he has insurance, but I'll
So
find out.
according to the DIMS, the defendant had turned in insurance information over to law enforcement. I'm gonna talk to the complainant, see if there was anything filed, and maybe we do something with the deductible.
Sure. Do you see if he has a license?
Yes, Your Honor, I'll.
You're not allowed to drive, Mr. Vasquez, unless you have a valid Texas driver license and liability insurance in your name. That is a part of your bond condition. If you pick up another case, if I find that you're driving without either, I will revoke your bond and put you in jail. No more PR bonds. Do you understand?
Yes, Judge. It's eligible, Your Honor.
Okay. You have a lawyer. It is your responsibility to stay in touch with Marcos and he'll tell you if and when you have to come back to court. So do you mind filing those conditions and then we'll sign it? We're gonna have conditions for you to sign. Once you sign the conditions, after that, you'll be free to go.
You're right, that's just no driving without a valid Texas license and
And
insurance.
no insurance, right? So we need a bond because it's in warrant status now. Roxanne, do you mind giving me a PSR? And do you want the cause number? You have it? Okay. I don't know if I see anything. If barring no criminal history, I'll set the bond at $100. I'm gonna give you a PR bond now, but like I said, you will not get any more. This is your one chance. You understand?
Is it?
Are you still employed at that Chick-fil-A?
Yes.
Okay, good. Okay, so he's gonna have a ton of paperwork to sign. We'll have you go to Victoria, sign a reset now. Do not leave until you sign our bond conditions, then you have to meet with Roxanne for your PR. Okay, thanks, Mark.
Appreciate it. Okay, just.
$100. You Steph, do you have the cost? And
Good morning, Judge. We're approaching on Miss Torrance. She's in custody. They did the T-RAS. We got the report. They are recommending, and Judge Torrey, maybe keep me honest here. Which they're recommending residential treatment, but community, which means that she would have to pay for it. And just to be completely candid,
doesn't have insurance.
no,
She's not gonna be able to pay for it.
yeah.
The alternative to the residential. Caseload, since you report 4 times a week, and then when staff, I repeat this. That's right, the other version is on the page. But this time.
What do you think?
Well, I understand that the DWI YA is probably a good program, but if she has to report 4 times a week, that's setting her up for failure because she's not going to to work. Because no employer is going to let somebody take off 4 times a week.
But so reports.
I'm gonna assume they screened her for sober report and maybe she didn't meet the recommendations.
How not? How would she not? I mean, really?
Her BAC was like 0.62, denied when he used since November 2024. So basically what she, I don't know, based
mean-
on what she's telling the assessors.
It's completely just,
Just to give you a little, what is kind of putting state in a wrong position is the BAC was low. We assumed there was something with tox. Tox still is not back, and I think people are rightfully slow, suppressed it because we still don't even have the lab back yet for the tox, blood alcohol.
when could you possibly get that back?
So
When's the last time you reached out to
I
them?
talked to them yesterday.
What'd they say?
No definitive conflict. And the reason we were reaching out was Anna had filed the trial packets, the blood alcohol trial packet. they would refuse to release that to her because they're not done with their analysis. I then called, maybe the state
It's
called.
really unbelievable how so many cases cave just because we can't get labs back. It's mind numbing, just how justice has to sit and wait because of the labs just can't get their shiesty together, man. It's.
Well, and Judge, just testing for tox is a little bit more complicated because one person tests for cocaine, another person tests for the benzodiazepines, another person tests for opioids. So it's not.
Don't just put it in a gas chromatograph?
Well, they have to tell it what to test for, and they can't do it all.
Person can't just put this and this and this and this? I mean, really? It didn't, I'm sorry, they didn't recommend Huey now. Leanna, I mean, I
Okay.
would go with the recommendation, you know?
Here's kind of the issue now too. Instead of a trial, I can't provide a blood packet because there's lab refusal turnover of blood packets without the full analysis being done, which has not been done.
What do you want to do?
I mean, even without the blood packet, I think it's a good trial case. But I would like the blood packet, obviously, to see, you know, if there's any issues with the blood and maybe it's not a 0.06. Maybe it's.
I've already suppressed it, haven't I?
Well, no, you just suppress the top
Tox.
analysis, not the blood alcohol. Because we had the blood alcohol will come back. The policy is if it comes back below 0.08,
And they sent, right. Okay, so
We have blood.
we have the blood, but
Yeah,
the blood is only at what, a 0.06?
And we just have the report. We don't actually have the full, like, picture of the vials, chain of custody
Yeah.
documents, all of that that Anna and I would both need
Right.
to try this.
If you want to do the probation, right, I'm certainly okay with it, but I think that that's probably the best way. I don't know.
Well, with Furman,
I know that, you know, the community resident is just too expensive. I can't.
Yeah.
Would she qualify for TAP funding? Would TAP funding pay for it?
Not the community residential, the only thing they can do is the IOP SOP. She'll still have to cover her devices and stuff as well. I don't know.
Yeah, I know that she had a seasonal position and that has ended, so she's not working right now. And obviously she hasn't been working since she's been in custody.
I'm at a loss. I don't know how to go forward.
Okay, well,
I mean, I obviously want to do what they recommend. How the IOP, how intense is it?
She'll go 3 times a week. She'll report to Harris County for the top funded one. And that was for 90 days. And then she'll do SOP for another 45 days, 3 times a week.
Why don't we just do the IOP SOP, right? And as a sanction, she goes to Hawaii. If she violates, if she messes up, ends up going to Hawaii. But that would definitely, we could make that happen after
We can make
that,
that
right?
happen after.
So just we let her know, look, you know, you're recommended to do community residential, obviously, you know, without insurance, you're not gonna be able to pay for it. We'll let you go to IOP SOP because it's basically the same thing, but 3 times a week
Okay.
instead of 4. And we'll pay for it for you. And if you know,
Okay,
if you mess up, you're going into inpatient and just let her know. And if she doesn't want to do that, then just set up a trial.
just volume shooting here. Can we put her on probation and violate her today and send her to Hawaii?
She has to be given like a chance to mess up.
Okay.
Because it wasn't recommended.
Okay, I just,
We have to go with what the recommendation.
yeah,
Like they didn't recommend Huey, so that's,
okay,
I know that it's probably. And I'm with you,
okay,
but we can't.
okay.
So
No, I'm
that's
just,
why we have to,
Given the time frame that everything happened and I haven't labs, she just doesn't qualify right now.
okay,
And you're understood, so you would only accept the probation off this. Their time, their jail time.
I want her.
yeah,
I get it.
we
I
just,
get it. I thought I'd just throw it out there.
Don't want to graduate with going upstairs. you know? Okay.
Let me talk to her and see.
I mean, really, that's a win on your behalf. She's not going to residential or doing anything now. We're giving her the opportunity and hopefully she can, you know, do it the right way. So it's all up to her.
Let me go chat with her.
Thank you.
Thank you.
Right here.
Sure.
You ready?
How are you doing? Jonathan Payton.
Hey.
Yes.
Okay.
And Judge, we were here last time. We thought that there was going to be a plea in the felony court, but there has not been one. I just spoke with Chief, and if we need to put it on the trial docket, we can do that for 7-1. That's because this next felony setting is 625.
What's going to happen then?
I don't know.
They're talking about probation. But the issue was that feds picked up the other cases of the co-defendants. So I think they're waiting to see what the feds are doing and
What's the difference by the feds with? How many co-defendants were there?
I think there were 3 or 4.
Can they pick up all the other co-defendants?
I think it's probably the ones that they actually have the strong case on, that they actually have probably on surveillance.
I don't want to speak if we are speculate as to where our friends may find the obviously, if there's a federal indictment pending on Agra,
Sure.
analysis, but.
What's the next setting for upstairs? Do you know? Is it a plea
Is
setting? Because if it's a plea
625.
setting, I'm happy to give you more time. But if
It's
it's
that
just,
disposition. That is in the 495th. I don't know much about that court. It was set for disposition on 5-1. It is now reset for disposition on 625.
so I guess let's set it for trial after the 625 date.
Okay,
Doesn't go, then
just set it for that 7-1, I guess.
Yeah.
Okay, that works. And Judge, also, I wanted to address his bond conditions for the curfew. He is currently in school and he's looking to get a job. So he gets out of class. I don't think he gets home till about 6. And his mom's here too, so she's on him and, you know, but he will also, he'll be graduating at the end of the month. I was going to see if there's any way we could get the curfew extended to 11 so he can get kind of a job for after when he gets out
he
of.
gets a job, we can talk.
Okay.
But I'm not going to just extend it for the sake of it. He's got 2 open ag robs.
Yes.
You know, the Fed's got the other guys.
Sure. Just so, yeah, we can come in and check.
If he gets a job, then we can talk. But just for the sake of, I hope I get one, then yeah, we'll talk afterwards. But
Okay.
get the job and then let me know.
Okay, that works.
Okay.
All right. Thanks, Judge.
Thanks.
Hey, Coach Ron,
Please.
how are you, Judge? Judge, I've got Fuentes Lobo on your docket this morning. He is entering the DWI program today. I've just sent just now everything over to the DA's, the emails that we're supposed to send it to. We're just waiting for the order to be filed. My only question is, does my client have to stay until that happens or can he leave now?
Or you know that they're 100% going to file it today?
It should, I would say 100%, don't, so here's the only potential issue is the contract as it was sent to us required him to have a portable device. He, from the time that we received the contract to today, he has a valid driver's license, which I've sent them. He has valid insurance, which I've sent them as well, with proof of the interlock installed as well. So everything should be fine. I've done that before where clients have gotten their driver's licenses between
The contract says portable versus interlock.
right, so they'll just have to,
Amend the
they'll just have
contract.
to amend, well, but they can amend it regardless after, right before they file the order with you, because they have to amend the end date all the time.
Vic, have you had him sign a reset yet, the defendant?
He has not signed a reset just yet, Judge. I wanted to approach you before I do anything else. Make sure that we got everything right.
As long as they're going to file it today, I'm okay with it. We'll just have him sign the reset now. You know, I mean, if there's a problem, I mean, he's going to have to come back, I guess. I don't
That's
know.
fine. Oh, you're okay with it?
Council for reset?
Does he have to go somewhere?
Well, if he doesn't have to, he'd like to go back to work if he can.
Cole, can you check or?
I just sent it like 2 minutes ago, so I don't,
Okay,
I can reapproach in like 15, 20 minutes if you'd like.
you know that they're going to file it 100%.
They should. I haven't had any issues with them before.
Okay, go for it.
Council for
Okay, thank you, Judge.
Just need him to sign the reset though for the
That's
year.
fine.
Hey, Carl, Frazier has a bond violation. Javon Frazier. So, I'm gonna put him
Two
on.
Frasers tomorrow. One for S and one for Z.
Do you want to put him on for tomorrow?
He's already, I think he is on.
No. It says for 5:15 for next week.
Okay. He called me Tuesday morning. He went down there Monday afternoon. Yes, they'd already closed the office. He was there at 4:30. So I told him to go there yesterday, Tuesday. So,
Was a no-show again. Two
What?
no-shows.
well, no, he was a no-show the other time, because he was in jail, remember? He got out of jail.
No, hey, when did Frazier get out?
He got out 4/27. That's why I responded to that email.
He no-showed this Tuesday.
He no-showed Monday, and then he was down there yesterday.
I have here he no-showed. Hold on, let me see. Okay. Do you see that he went for a test yesterday?
Can I get a case?
Yeah, you ready?
Yes.
254-7651.
You're supposed to remember those names.
She is good.
Unless you. Yes, I don't know.
That's a possibility because it's not in an order, so I don't know. Hopefully they did, but I don't know.
I'm sure that he would.
If not, you want to put him on for Friday? Can you be here Friday? According to the system, it says 5:50. But if you want to bring him in tomorrow, then we can do it tomorrow.
May have. He was looking on. I think he got the 15th when he bonded out again.
So he didn't go on Monday, he didn't go on Tuesday, you see? No? Okay.
What do you want to do?
Roxanne, can I give you a cause number? Frazier? Yeah, did he go test yesterday?
No, Judge, you didn't. You didn't show up.
Okay, so for Carl, any day this week, whatever you want.
Friday?
Done. I guess just let him know. We'll put him on Friday. Thanks.
Thank you.
Hi. Yes.
Judge,
Hey, good morning.
you're on Matthew Owen this morning.
Which one?
Matthew Owen.
Owen. Okay.
It's a very similar situation to the previous PTI case that you just heard about. He's approved for PTI. We submitted the signed contract. He has the device, paid the fee. But we let them know when we signed the contract, we submitted it yesterday, that he has a company vehicle and that we needed either an exception or to add a portable. And they said, okay, here's an amended contract back. You only need one device, but he needs to get the portable first. So he tried to make an appointment yesterday. As you know, Judge, it takes some time to get an appointment. We just need some time for him.
Has he made an appointment yet?
He's been trying to get an appointment. He hasn't been able to get one scheduled yet. He tried to make one yesterday. He said he kind of got the runaround from Smart Start. But I've impressed upon him to get this done as soon as
And
possible.
it's 200 days.
I
How
know,
long do you
Judge.
want?
I know.
I mean, I'll give you a week. If he doesn't have it in a week, I'm gonna roll him day for day until he has it.
Okay, Judge, I appreciate that.
Yeah, this is the last reset.
I understand. Thank you, Judge. Maybe excuse.
Yes, sir.
I have Martin Torres on docket today. I believe we have to address bail. He did pick up a case. Well, he picked up two. He picked up a felony and then another misdemeanor. On his,
Is he in jail now?
yes, he's in the holdover.
How do you pick up an arson?
That is correct.
Wait. So on 4/6/25, he picks up a mischief, right? We've got the bond set at 5,002. They did not give him a PR bond.
Correct.
4/22 picks up an arson. And then now on 5/6/25, he picks up an interference, but he gets a PR bond on the interference.
Yeah, correct, Judge.
So, he's not made bond. I guess what I'm
He
gonna
goes to
do.
felony tomorrow.
Okay.
I don't think that the felony judge is gonna lower that bond to 30,000. He did express to me that he's probably not going to be able to make it. So as far as our cases, can we keep both at like 5,000?
Yes, I was gonna put the interference, same thing at 5,002.
Okay,
Leave it at that.
okay.
I'm not gonna give them
I understand, Judge.
possibly.
Yeah.
So we'll leave both at 5,002.
Okay.
And I have to do bail order. Okay. And then just, do you want to say for the next day or whatever day? I'm happy with whatever.
Okay, thank you, Judge.
Thanks. Okay, hi.
Good morning, Judge. I have Miss Collins on docket. She's in custody. She's the one that we,
Did we get her?
yes, she's, yes, so I did let you know. So can we bring her out by chance? That way she can, to reinstate her bond. Because she's the one that we issued the bench warrant
I
for.
remember, hold on, so has she made bond on the felony?
So yeah, her probation was reinstated in Galveston.
Okay.
So she's back on that. So she's good over there. So we can proceed without any holds over here.
What is your position, state? So the deal is this, is that she picks up an assault here in August of last year. She's on felony probation at the time, right?
Yes,
They
Judge.
revoke her bond, put her in custody. She sits in custody for a long time in Galveston, right?
Judge.
They just now reinstated her probation
Yes, Judge.
over there. So we bench warrant her back over here. So that's what we are. She wants a PR bond on the assault.
And so we did that because to get her here to actually take care of the case.
To get her here to
Yes.
try to take care of everything.
And so she hasn't done anything while on bond in this case, no violations or anything like that. And
She's been in custody the whole
she's
time.
in, yes, well, for the most part, yes, she was in custody. So on,
Is she in a holdover right now?
yes.
Can we talk about a resolution? So
Yeah,
that
we talked about the third one.
we talked about deferred?
Yeah.
Yeah.
Yeah. Okay, I'm gonna go, I'm gonna read her.
Just let me know when you're done.
Sorry, Judge.
Yeah, hi. Hi,
Edelbert Rosas on docket, he's in the box.
it's bond violations.
Yes. Indicated to me that they,
Do you speak English?
yes.
Yeah, we get one more.
So where are we now with this case?
On this one here, we got an email, he was accepted into the PTI, and we're hoping we can do a walkthrough on the cast this morning.
Come up, Mr. Rosas. You are now at a strict no tolerance state. If you ever miss again, I will revoke your bond and put you in jail. Do you understand? Sir. Okay, I'm not gonna play any more games. The next time you miss a test, it's not gonna go well for you. We will do a walkthrough now. No more waived appearances. He must appear at every setting, and then we'll set you off for about a week and a half to see where we are with getting the device and everything. Okay? All right, thanks.
Morning, Judge. Can I approach you? Judge, I got Mr. Basilio Montañez, Judge. It's FSGI. He's got to pay $804 restitution. He said he can get that in 3 weeks. So we're just asking for a 3 weeks extension to pay that restitution.
Okay, if it's not done in 3 weeks, I'm rolling him day for day. Let him know.
Yes, sir.
184 now.
Right, sir.
After that, it, okay.
Yes, sir. I'll let him know. Thank you.
Hi. Great to see you, Sonia. It's been a while. How are you? Good. So we have Mr. Rooker.
So we have, done the paperwork for a deferred.
You have what?
We've done the paperwork for a deferred.
Okay, is that what you want to do?
Yes, John.
Okay, Mom and Dad, you can come up. Thank you so much for coming, guys. You know, you're entering into a very, you're entering into a very serious agreement now, Mr. Rooker. And if you think that the way that you've acted while you're on bond, it's gonna work like this while you're on probation, you're very mistaken. It's not going to. I'm telling you now, the agreement that you enter into, while it's great if you can complete it because you don't end up with a conviction, you give up nearly every right known to man by entering into this deferred. If you violate any condition, you were looking at an entire year in jail. Do you understand? So is he living with you guys now? Because I can't do this alone. While he's been on bond, it's been a veritable nightmare, trying to even get him here. How are you going to be able to make this when you can't even make it to court?
So his situation has drastically changed. He has gone to inpatient rehab. He is currently in outpatient supportive treatment that he attends 3 times a week. He's been opioid free for 6 months now. He is working, he has his own vehicle, so things are very different, and he has moved back. So-
If I send him for a drug test now, what's going to happen?
Show for THC.